great honor to be here this morning, to be with all of you. But though I was informed a few weeks back that I would have a chance of meeting Professor Mark Gallanter here, whom I had met some 30 years back in Hyderabad. The second time I met him yesterday here. There's one name very familiar to Indian lawyers for his work. Now, when I was invited to be here this morning, the choice was given to me regarding the topic of today's speech. Of course, with the suggestion that the topic could be choosing judges for democratic India. I readily accepted the suggestion for more than one reason. It is a topic of great importance for any democracy, not only India, any democracy. It's a topic which is being very vigorously debated in India for the last couple of years for various reasons which are now recorded in history. And thirdly, it makes my job a little easier because I was a member of the bench which considered the legality of the Constitution 99th Amendment, by which the Constitution was amended, making certain alterations in the original text of the Constitution regarding the procedure by which judges to the Constitutional Courts of India are chosen or appointed. So in that connection, I had to study that problem very intensely. And in the very recent past, hardly a year back. Therefore, this topic, speaking on this topic would make my job a little easier. Therefore, I accepted the suggestion. Friends, all of you know, no two democracies are identical. United States is a democracy. India is a democracy. So are many countries. Britain is a democracy. But each one of these democracies have their own distinguishing features. Perhaps the only common feature is that in all these democracies, the rulers are chosen periodically by some process of election. The process of election itself may vary from place to place, time to time, the same place. But that is the baseline. The other common feature in all these democratic forms of government is the distribution of powers between the various organs of the state, the legislative organ, the executive wing of the state, and the judicial branch of the state. I think that's the favorite expression of the American jurists, the judicial branch, or what you call what is described as the least dangerous branch. Now, while the members of the legislature are elected in any democracy, the members of the executive are in turn elected either directly by the people or chosen by the elected representatives of the people. Members of the judiciary are generally appointed but not elected. I'm conscious of the fact that US, I think some 34, 35 states have elected judiciaries up to a particular level. But at the highest level, even in US, to the Supreme Court, judges are appointed but still not elected. The text of the Constitution only mandates the appointment of judges to the Supreme Court. When India became a republic, an independent republic, a sovereign republic, 1950, it needed a constitutional document to guide its governance. A constant assembly which debated over the future form of government brought into existence the Constitution of India as it was originally enacted. Dealing with the judiciary, the Constitution contemplated, the Constitution makers made provisions for the establishment of a two-tier constitutional court legal system. The Supreme Court of India and the High Courts at the level of the states, the federal units you may call them. Though there is always a question of how constitutional the Constitution in the sense of permanence of the High Courts are. The reason is this. The reason for this doubt or question is this. Unlike the American Constitution, the federal units are not permanent in India, permanent in the constitutional sense. States could be created or their boundaries could be altered even to the extent of totally extinguishing the existence of a particular political unit, merging the unit into other parts. In theory, it's possible, though it's not an exercise undertaken on a regular basis. Initially, in 1950s, after the formation of the Federation, this exercise was undertaken. A States Reorganization Act was passed. States based on linguistic identification were created. Subsequently, due to various political developments, a few new states were brought into existence by bifurcating the existing larger states. So in that sense, the states themselves are not permanent units like the Union of India. They're administrative units in a particular sense. And it's a huge debate. I don't want to enter that area for today. Relevant in the context is the text of the Constitution mandate that there shall be a High Court for every state. Now, in that sense, if a particular state is bifurcated, for example, it happened in the recent past in 2014, the erstwhile state of Andhra Pradesh, to which I belong to, was bifurcated. Though the High Court continues to be a common High Court even as on today after 2 years, the law providing for the bifurcation of the erstwhile state of Andhra Pradesh, dividing into Andhra Pradesh and Telangana, contemplates the establishment of a separate High Court for each of these two newly created units. In that sense, whether strictly the High Courts are constitutional courts in that sense is perhaps a question that requires a larger debate, but they do find a place in the text of the Constitution. The appointment process of the judges of these bodies, the Supreme Court and the High Courts, is also provided in the text of the Constitution. Broadly speaking, the Constitution says that judges to these courts are to be appointed by the President of India in consultation with the Chief Justice of India. Article 124 and 207 of the Constitution of India deal with the appointment process, dealing with the appointment process of the judges of the Supreme Court and the High Courts respectively. In the context of the appointment of Supreme Court judges, the President is required to necessarily consult the Chief Justice and such other judges of the Supreme Court or even High Courts for that matter in making the appointment of the judges of the Supreme Court. When it comes to the question of making appointment of judges of the High Courts, the President is required to consult the Governor of the state in the context of Indian Constitution. That means the state government, because the Governor is obliged to act in accordance with the advice of the elected representatives of the state, that what we call the cabinet. The Governor and the Chief Justice of the High Court are required to be consulted by the President, apart from the Chief Justice of India. Thank you. Thank you. Textually, it is, though it is said that the President shall appoint in consultation, but in practice, for the last 65 years, the proposals for the appointment of judges to these courts always originated from the court level. If it is a proposal for the elevation of somebody to the bench of the High Court, the proposal came from the Chief Justice of the High Court. It went to the local, the state government. After the state government's comments, whatever they have to make, the proposal goes to the Government of India. The Government of India, after an appropriate consideration of the matter, forwards the proposal to the Chief Justice of India. And after the Chief Justice of India clears the names, the matter goes back to the Government of India, eventually to the President, in whose name the warrant of appointment is issued. This is the practice, a practice which has its origins in the practices which were established prior to the independence and the government of various governments of India acts, either 1935 or its predecessors. This was the practice which was being followed, and the same practice continued. Now, the question is, what is meant by this expression, consultation? Well, the text of the Constitution demands that judges are to be appointed in consultation with the Chief Justice of India. What exactly is contemplated by the Constitution is the question. For almost a quarter century, a little over a quarter century, this question never troubled any wing of the Indian constitutional governance. Matters moved smoothly. But I've prepared a text, I'm not reading it out deliberately. I've given the relevant information there. Barring the very few occasions, most of the time, the proposals made by the judiciary were accepted by the government and appointments were made. There are, I think, in the first 1.5 decades, hardly 6 or 7 occasions when the government disagreed with the proposals made by the judiciary. Sometime in mid-70s, the question assumed significance. I'm students of law in this university. I'm sure you must be acquainted with the text of the Constitution to some extent. The Indian Constitution has a provision dealing with the proclamation of emergency.